The fluorescent lights buzzed overhead like a swarm of angry insects as I sat across from the HR manager, her glittery pen tapping rhythmically against the manila folder. The fake ficus plant beside her desk drooped under the artificial air, mirroring the hollow empathy in the room. My pulse thrummed in my ears while the consultant droned on about synergizing lean transformation and organizational agility. Everyone knew what it meant. Cuts were coming, and the survivors would pretend it was a mercy. When he reached my name, the envelope slid across the polished table like a quiet threat. Inside, the termination letter, a fresh reminder of the non-compete clause binding me for 12 months across every jurisdiction they could imagine, and that smugly bolded line about remaining bound by your obligations. My ex-boss leaned in, his voice dripping with false sincerity. This isn't personal, Elena. We're just streamlining for the future. I didn't flinch. Humiliation flooded my veins like ice water. But I kept my face neutral, nodding as if Miranda rights were being read instead of my career being erased. This was the same man who had stapled his name over my project roadmaps, pitched my ideas to the board as his own genius, and relied on my late nights for 3 years of failed pivots. He couldn't lead a team meeting without my prep notes. Yet here he was, handing me a cardboard box while lecturing on mutual respect in transitions. I gathered my things quietly, stapler, notebooks, the mug that read "Coffee is my love language," and crucially, every original document, offer letter, promotion emails, performance reviews, even the old contract with the pre-merger company header. They had rebranded after the acquisition but never bothered updating my paperwork properly. I noticed the mismatch immediately. The termination memo bore the flashy, new logo, but my contract tied to the old entity. HR tried softening the blow. We know this is hard, but the non-compete ensures a clean break. Think of it as a sabbatical. A sabbatical? This was a gag order dressed in corporate jargon, designed to keep me sidelined while they repurposed my workflows under new titles. I wanted to laugh bitterly, but pride held it in. As I walked past the lobby where the new intern filmed TikToks, the realities sank deeper. No severance. No garden leave pay. Just the mortgage notice arriving the same day as the gas bill, $2, for 18 due by Friday. Or enjoy eviction proceedings. At home, I spooned peanut butter straight from the jar, staring at the overdue notices while my sister's text blinked. We've got you. She juggled 3 kids and her own chaos. I hated feeling like a burden. Pride, that stubborn old friend, kept me from replying immediately. I was raised to carry my weight invisibly, like the HVAC system humming quietly in the background. Recruiters started calling within days. Some sounded genuine, probing my availability with professional curiosity. Others had that oily edge, asking pointedly, "You're not breaching your non-compete by talking, right?" Word had spread fast, even though I hadn't contacted a single client or updated my LinkedIn status. Their nervousness leaked through. One lunch with an old coworker, now in HR at a logistics firm, just venting over salads, got twisted into indirect market interference in their eyes. Then the certified cease-and-desist arrived. Signature required. It accused me of positioning myself competitively by merely applying in my field, citing that innocent lunch as evidence. No proof of poaching, just audacity. I added it to my emergency folder labeled "If they get stupid," already thick with policy violations, unpaid garden leave evidence, and Slack messages showing retaliation masked as restructuring. I reread the non-compete clause until my eyes ached. Signed 6 weeks after starting. No new role. No bonus. No extra consideration. Just a Friday ambush. Sign this or reconsider your place. Under duress. Without value exchanged. It felt shaky. Sloppy drafting lumped non-solicit, non-disparagement, and non-compete into one bloated paragraph. In many states, especially with termination without cause and no garden leave, such clauses crumbled. Financial pressure mounted. Bills piled up. I applied vaguely, smiled through calls, waited for them to flinch. Their overreach only confirmed my suspicions. They feared what I knew. The operations I had built while they played buzzword games. Silence became my strategy, not surrender, but preparation. I opened a browser tab and searched declaratory judgment, non-compete, wrongful termination, lack of consideration, no garden leave. That's when I booked the appointment with a quiet attorney whose reviews praised results over drama. Her office was unassuming, worn leather chair, noisy coffee maker, stacks of folders. I handed over my collection, like a confession. She skimmed methodically, then looked up. They're bluffing. Let's file. No theatrics. Just a motion seeking declaratory judgment to invalidate the non-compete on grounds of wrongful termination without cause, insufficient consideration, and failure to provide garden leave. That night, sleep evaded me, not from fear, but from a sharp, bitter clarity, like balancing on a knife's edge, refusing to retreat. They wanted me invisible, perhaps candle-making until the clause expired. Instead, I chose evidence over ego. Their response arrived swiftly. Counsel filed an affidavit painting me as an indispensable strategic asset turned professional threat. The contradiction nearly made me laugh. Critical yesterday, dangerous today. It admitted budgetary reorganization termination, shredding any for cause pretense, and noted the effective date mismatch with my final pay stub. No continuation pay. No garden leave. I met my attorney again. She handed me our exhibit list, 17 documents, tabbed and time-stamped, including the garden leave policy I never received, the termination memo on mismatched letterhead, and pay stubs ending short of obligations. This is solid, she said calmly. Back home, I spread everything across the living room floor, like preparing for battle. Contracts versus memos. Highlighters marking contradictions. Dates didn't align. Contract signed August 2nd with old entity, tax ID 71290W. Acquisition closed September 9th. Yet internal emails and rebrand announcements used the new name and logo from mid-August. No assignment clause. No employee consent, just a quiet switch. They assumed no one would check footers against filing dates. But I had built their onboarding tracker. I remembered every buried policy update. Post-its bloomed in colors, green for date mismatches, orange for policy breaches, red for damning CEO emails about trimming fat with my name highlighted, sent days before my exit. I subpoenaed payroll records for garden leave disbursements over the prior year. The response, zero. The policy existed on paper but was never enforced, a phantom clause. Now the trail wasn't defensive, it became offensive. Pattern emerged, calculated disregard. Betting on my silence. I delivered a thicker binder to my lawyer. She murmured, tight. Their junior associate emailed a polite, meet and confer request. Tone laced with smugness about amicable resolution. But the footer betrayed them. Entity ID 86472B. Not matching my contracts 71290W. No sign transfer. No jurisdiction. I printed it. Highlighted. Added as Exhibit 21. Their letters escalated. Accusing client solicitation, none occurred. Contract interference. Damaging morale, via a networking badge with my last name. My lawyer circled the paragraph. Excessive bundling of clauses. Judges despise overreach, especially with unpaid obligations and entity gaps. Every page proved facts, not feelings. Offer letter. Promotions. Pay trail. Policy PDF. Subpoena response. Pre-acquisition emails. Footer error. A guillotine of paperwork. They fought with vibes, I built with receipts. The hearing room felt sterile. Gray carpet. Ergonomic chairs. An ancient ficus. I sat with my binder. Hands steady. My lawyer radiated quiet confidence. My ex-boss Jake entered. Thinner-haired but ego intact, adjusting cufflinks as if prepping a TED Talk. He testified, I was a key asset, heavily integrated, but termination was transitional optimization post-acquisition, strategic reshuffling for sustainability. Translation: budget cuts targeting expensive staff. My lawyer cross-examined with precision. Was this performance-based?
No.
Disciplinary?
No.
With cause?
No.
Budgetary. The record now showed, without cause termination. Next, produce signed assignment documents transferring the contract to the new entity? Jake stammered, glancing at counsel. No record, the judge pressed. He admitted ignorance. Payroll showing garden leave compensation? Objection overruled. To my knowledge, no payments were made. The judge reviewed our exhibits. She tapped the termination memo. Logo adopted mid-August. Acquisition September. Basis of enforcement under non-party entity. The room's air thickened. Section of Labor Code requires voluntary departure. Cause termination. Or consideration via garden leave. None present here. She noted exhaustive documentation. No evidence of breaches on my side. Speculative harm in their cease and desist. Unless new compelling evidence. No basis to restrict employment in her field. Recess called. In the recess room. Bad coffee went untouched. Across the hall. Jake paced visibly agitated through a briefly open door. A note slid to us. Settle now. My lawyer leaned in. They're folding. Hold steady. 15 minutes later. Their counsel returned with forced diplomacy. Offer. Immediate non-compete tear-up. Legal fees reimbursed. Formal clarification to staff and partners that I faced no restrictions. Neutral reference commitment. Jake sat stone-faced beside him. I closed my binder. One more clause. Liquidated damages. Any future representation of restriction triggers fixed penalty per incident, enough to deter. Indexed. No ambiguity. Draft language. Pre-prepared weeks earlier. Slid across. They read. Conferred.
Signed.
The threat dissolved into signed PDFs and a clerk stamp. We shook hands formally. I walked out spine straight, breathing deeper. Minute order docketed soon. They entered swinging threats, exited writing checks. No public post. No LinkedIn victory lap. Home. I framed the order above my desk near an outlet. Reminder every plugin. Documentation is armor. Silence sharpens the blade. 2 weeks later. New role at a tight-knit ops team. No fake plants. Authentic leadership. CEO handled onboarding herself. HR paused at my custom clause. No non-compete ever as employment condition. She raised brows. Smart. Background check had surfaced the case file, cautionary tale spreading quietly in HR circles. Settled smoothly. No warnings reached them. The liquidated damages clause deterred whispers. Jake's company went silent, hoping I'd forget. But I frame evidence. Next executive bluster faces precedent, not opinion. I needed stable ground after disposability claims. Now I have it. They mistook quiet for weakness. It was aim. The story lingers. How meticulous silence, paper trails, and legal precision turned corporate overreach into liberation. What price dignity when power assumes fear lasts longer than truth?